Hello, everyone. Okay. Good evening, everyone. There we go. There we go. Make sure everyone is excited for this conversation as I am. I am Ebony Nelson. I have the honor and pleasure of serving as dean of this wonderful law school. And on behalf of UConn Law's faculty, staff, students, and alumni, I welcome you all to this special program. The Law School's In Conversation, the Supreme Court series, brings scholars and experts together to share their insights about U.S. Supreme Court decisions with the law school and broader community. This evening's program, titled Electoral Anxiety, Courts, Race, and Democracy, will consider the Supreme Court's recent decisions and preview important upcoming cases in the area of election law, exploring issues relating to voter access, minority representation, candidate eligibility, and the role of courts in policing the electoral process. This conversation is not only timely, but also necessary, given the important role voting and elections play in protecting and advancing our democracy. Tonight and this year's In Conversation series would not have been possible without the dedication and hard work of our amazing Associate Dean for Faculty Development and Intellectual Life, Ann Daly. Please join me in thanking Ann. This was our first year having this series, and we were very ambitious, perhaps a little too ambitious, but Ann has pulled them all off, and this is our third and final one for this inaugural year. So again, congratulations, Ann. It's been absolutely terrific. I also thank our events, our communications, and information technology and catering departments for their assistance in facilitating this evening's program and the entire series. Dean Daly has assembled a stellar group of leading scholars for this evening's discussion, and I welcome them and thank them for being here to participate. I also thank and am delighted to welcome back home our moderator, Professor Doug Spencer. Professor Spencer, yes? Professor Spencer is Professor of Law and Associate Dean for Faculty Affairs and Research at the University of Colorado at Boulder. But perhaps more important to know, from 2013 to 2021, Professor Spencer was a beloved member of our own UConn Law faculty, and we're absolutely thrilled to have him back tonight. So welcome again, Doug. Professor Spencer's research addresses the role of prejudice and racial attitudes in voting rights litigation, the empirical implications of campaign finance regulations, and the ways that our voting system contributes to growing inequality in America. He has published widely in prominent law journals and been featured on national news programs. In addition to receiving his BA from Columbia and his JD from Berkeley, he also holds a PhD in jurisprudence and social policy from Berkeley. Prior to law teaching, Professor Spencer was a law clerk at the Lawyers Committee for Civil Rights in San Francisco and an election monitor in Thailand for the Asian Network for Free Elections. Doug, we're absolutely thrilled and so happy to have you back. I'll turn the program over to you, and thank you and welcome to you all.
Check. Hello, can you hear me? Okay, excellent. Thank you. Thank you so much, Dean Nelson, for having us. Thank you, Ann, for putting this together, inviting us out here. It's really, really, really great to be in Hartford, Connecticut tonight and to talk about election law. So in the mingling that just happened back there, I overheard some conversations and was part of some conversations that basically went along the lines of, am I going to leave this room more depressed than when I came here? And I really hope that's not the case. We have not gathered a panel of cynics and downers. We're trying to educate people interested in election law about what's going on. Certainly some of this is not good news for some of us. I think reasonable minds can disagree about many of the topics that we'll discuss. But the goal of our discussion today is to provide some context for cases you may have read about that have happened in the court recently, cases that are upcoming on the court's docket. There are a few cases the court has heard oral argument for, and yet we still are waiting on opinions, and so hopefully we'll have some insights about what we might expect, and then when you read those opinions in the news, you'll be more educated about it. And I think this is a really fantastic format to talk about the Supreme Court, to think about broadly the way that it's addressing some of these issues. So I'm really pleased to introduce you to the panelists who will be talking to us, or maybe the discussants, hoping to have an actual informal conversation about this up here. And I'll tell you a little bit about each of them. You'll get to know them more throughout the night. We'll just kind of in order of how they're sitting up here. Guy Charles is Charles Ogletree Jr. Professor of Law and Faculty Director of the Charles Hamilton Houston Institute for Race and Justice. Guy is the editor of a leading election law casebook. Guy is writing 2 books at the current moment, one of which I hope we can talk about in a little bit, but both of the books are about the use of race in thinking about political power and election law to distribute resources and power, and thinking about a new model going forward in the United States, breaking away from a long historical pattern that we've seen in the last 50 plus years. And so I'm excited to hear more about that project. Ruth Greenwood is director of the Election Law Clinic at Harvard Law School. Ruth is an incredible attorney in her own right, worked for the Lawyers Committee for Civil Rights in Chicago, then worked for the Campaign Legal Center, took 2 cases, one of which, you may have heard of both of them, but one of which I'm sure you've heard of, Rucho v. Common Cause, was part of the trial team that took that case to the United States Supreme Court, and so knows both the inner workings of election law on the ground, understands how the courts work, and she now has taken her talents to Harvard, where she does all of this with a rotating cast of students who don't know what they're doing, and still does an incredible job. So some of my favorite runnings into Ruth's work is when I see briefs that the clinic has posted in these cases that are incredible. And I'm jealous because I can't give my students an opportunity like that to be so involved, and she's doing that, and it's really inspiring. Yasmin Dawood joins us from the University of Toronto, where she's Professor of Law and Canada Research Chair in Democracy, Constitutionalism, and Electoral Law. Her scholarship's broadly concerned with improving fairness and democratic governance, and as I was reading through, is published in every leading journal that you could imagine in your minds in both law and political science. Something that Yasmin doesn't know is that yesterday in my election law class, University of Colorado, we read one of her papers called Classifying Corruption from many years ago. But I have learned that that's one of my favorite papers actually in the entire canon of election law, and for you it may have just been a one-off. But it's really a thoughtful piece, and some topics that I hope that we can touch on tonight in some form. Okay, so the topic of the discussion tonight is about anxiety about the election. And we didn't do a poll, so I can only guess what you might be anxious about. People are anxious about the people who are involved in elections, the candidates who are running. Do they represent the American electorate? Are they young enough to survive a term? Do they have the character to govern? Others may share some anxiety about the future in the way that power is distributed in our society. Will the wealthy continue to control all of the resources, both economically and politically? Some people may have some anxiety about the mechanics of elections. There's an enormous amount of turnover among election workers, poll workers, election judges, likely to be filled by people who might have agendas that aren't 100% committed to getting things right, but maybe committed to getting things right for their side. So there may be some anxiety about that. There may be some anxiety about campaign finance and corruption and the way that our government's running. So our goal tonight is not to address every possible topic. Our goal is not really to assuage or to exacerbate your anxiety. But what we're going to try to do, because we're at a law school, is evaluate some of these topics the way that lawyers evaluate them, which is understanding what is the role that law has played and can play in addressing some of these concerns. And I actually want to begin by thinking about minority representation in the United States. And we'll touch on some of these other topics later. One of the most watched cases in the Supreme Court this last term was a challenge to the redistricting plan in Alabama. The case was Allen versus Milligan. And there, the state of Alabama had drawn new maps after the newest census, and they had drawn an opportunity district for black voters in Alabama. One of their seven districts for Congress was what's deemed an opportunity district for African American voters, meaning in that district, African American voters had a chance equal to other racial and ethnic groups to elect a candidate of their choice. The problem is that the African American population in Alabama is almost 28%. And so if you look at the 7 districts that Alabama has, you might think a fair outcome would be to draw 2 districts in which there was a fair opportunity for African American voters. And yet Alabama drew 1 district. And so they were sued, alleging they had violated the Voting Rights Act. And the reason I think this case was so prominent in the press was because this was a chance for the Supreme Court to either strike down the Voting Rights Act of 1965 or to severely curtail its reach and power. And yet when the decision was issued, it was called a surprise, almost universally. This was a surprise. There was one person that I know of who said this really wasn't a surprise, and that was Guy Charles. Guy sent an email out to a listserv of election law professors who were saying, oh my gosh, this case is a surprise. It's totally a shock that it came out this way. And Guy sent a note to everybody and said, I'm not so surprised. So I want, Guy, to put you on the spot a little bit and have you explain to us maybe if you could summarize what about this case.
Do you remember what I said?
I think you said, I don't know why you're all so surprised. But ultimately, the Supreme Court did not strike down the Voting Rights Act. In fact, they endorsed the way that it had been used in a way that there was fear they would not do just because of other writings, particularly John Roberts in the past, skepticism about the reach of the Voting Rights Act in this particular way. And then the court came down and said, of course we're going to follow our precedent. So either what made the rest of us so shocked that they said, of course we'll follow that precedent, or what made you so sanguine about that whole process?
Right, a couple of things. So Doug is obviously right that the big question, and this has been true, quite frankly, for a very long time, in the context of voting rights, was when is the court going to take an axe to important elements of the Voting Rights Act? So when I was in law school in 1993, the case of Shaw versus Reno came out. And in fact, we took an election law class right after that case came down. And then it seemed as if the court was getting ready to strike down important parts of the Voting Rights Act. This was a case, the racial gerrymandering case out of North Carolina. And the question raised by that case was whether drawing majority-minority districts came under the aegis of the 14th Amendment. Can you state a claim, a constitutional claim, when the government draws districts under the VRA and uses race? And the court said that race-conscious districting was subject to a constitutional analysis, and basically everybody thought, oh, okay, this is signaling the end for the VRA, especially for Section 2 of the VRA. So this is in 1993. 2 years later, in 1995, the Supreme Court decided Miller versus Johnson, and there the court had to figure out, well, what does it mean to say that you can state a constitutional claim that when you draw districts on the basis of race, you could also state a 14th Amendment claim, notwithstanding what Section 2 of the Voting Rights Act has to say. And essentially where the court ended up is with a compromise standard where it essentially said you can do race, but it can't be too much. So it articulated the predominant standard. Race can't predominate when you're drawing a district. Now, if you do this for a living, in some respects you might say, look, this doesn't make any sense because when you're drawing a majority-minority district, right, you're drawing a district that is intended to provide a remedy, essentially, for a particular racial group. Racial representation is an important factor. But put aside your logic of thinking about this and sort of think about it from an institutional perspective, which is a court that is trying to hold on to a couple things at the same time. It is not yet ready to move its full Equal Protection Clause jurisprudence into the voting rights domain, and at the same time it sees a need for race and representation, so it's trying to find a compromise position. Okay, one more point to make about this to fully answer Doug's question. Fast forward a few years later, there's a challenge to Section 5 of the Voting Rights Act, and in a case called Northwest Austin Utility District number 1, everyone thought that this is where the court was going to take down Section 5 of the Voting Rights Act, and Justice John Roberts wrote an opinion that basically outlined why the Section 5 was unconstitutional, and then just veered around that and said, okay, but we're going to decide this on statutory grounds. So the court signals, but then moves around it. But not too long after that, in Shelby County versus Holder in 2013, so Northwest Austin was 2009, 2013, the court then says, oh, by the way, we told you. Okay, so if you know anything about Justice John Roberts' jurisprudence, it seems to me that there's a pattern, which is he will move incrementally and say, look, this isn't that big of a deal. This is not that much of a problem, but take a step. And then later reinterpret what happened before, as he did in Shelby County versus Holder, and said, hey, we warned you, Congress. You know, a few years ago, we told you this was the problem. Now, what happened after 2009 is that everybody declared, the civil rights groups declared victory, essentially. They said, hey, you know, the Voting Rights Act is a really important one. The court didn't even dare strike it down. We're safe. You know, now, of course, I think they knew that they weren't fully safe, but part of the lore was to make that articulation. So my sense of Milligan is a court that moves incrementally, that slowly makes its way and builds a type of a record, and then eventually, before one realizes it, the court then sweeps the rug from underneath everyone, and you realize that the thing that you were relying on is gone. So I think Allen is a slow it represents essentially the version of Northwest Austin Utility District number 1. I think that's the analogy. And eventually the Shelby County versus Holder is coming up. If you take into account the court's affirmative action decision, there is a collision course between a color blindness jurisprudence, right, slowly articulating a color blindness jurisprudence against a statute that provides for racial remedy and representation. Those two things, in the words of Justice Scalia, those two things are going to clash, and when they clash, it's fairly clear what's going to give. So in many respects, part of what's interesting about Allen is it's true that the court didn't strike down the VRA, but it's also true that if you follow the court's jurisprudence, you see that it walks fairly slowly, and then once there's a sense of comfort, when Shelby County came, there was a lot of surprise because it seemed like, well, wait a minute, 4 years earlier you said everything was fine, but now you did this. But I think we've learned our lessons since then, and we could see what's coming down the pike.
Can I jump in here? So I am quite the eternal optimist, which is how I survive in this world of voting rights. And that was so depressing. Because as you said that, I suddenly realized the two cases, I'm a serial Supreme Court loser, the two cases I took up, Whitford v. Gill, didn't really lose, got kicked back on standing, and then Rousseau, bang, totally lost. So cases that I was more excited about, Allen v. Milligan, maybe we're going to get to keep something. I'm like, oh my goodness, you're totally right. And the other one I was thinking about is Moore v. Harper, which was about whether state Supreme Courts are able to interpret their own laws, and the court mostly left that alone, but there's enough language in there for the next case to really destroy it. So that's terrible. Yeah, no, I have one optimistic spin on this, which is that I was sort of had my faith shattered in the Supreme Court back in 2019. That decision in Rousseau came down when I was very heavily pregnant, and I very quickly had a baby and was like, oh, this is fine, I have a baby, forget about the Supreme Court, and then went back to practice. But because of that, I have sort of turned my attention to state courts and state legislation, and so we are sitting here in Connecticut, which is the latest state to pass a state voting rights act. It is part of a growing movement to try to make protections at the state level. And I realize that that doesn't necessarily work everywhere in terms of new legislation, but there are also moves to interpret state constitutions in light of a democracy canon. And so I think that a lot of us are litigating a lot more in state court than we thought that we would, just because the US Supreme Court has sort of let us down a lot. That said, as long as Milligan sticks around, right, there's still enough time to keep winning a couple more cases and build some power for historically disenfranchised communities.
Oh yeah, go ahead.
Jump in. One thing that I noticed in the Milligan decision was that Chief Justice Roberts talks about how since 2010, there have been less than 10 successful plaintiffs in racial gerrymandering cases under the VRA. So when I read that, I paused and I thought, where's he going with this? Does this mean that, that's why he's being, so open to keeping Milligan or to keeping the VRA on the books because it doesn't really matter? Or is this a setup for we don't need this anymore because we've only had, under 10 successful plaintiffs? So that was one thing that occurred to me. And I completely agree with you, Guy, that the timing of the Students for Fair Admission, I think, was relevant, right? That came out just, a few days after Milligan. So having one case that went one way and one case that went the other way, I think gave this impression of balance. And so that's what I thought as well in terms of the timing of those two decisions. I don't think that was an accident.
When Rucho came out at the same term, in fact, the same day, they rejected the attempt to put the citizenship question on the census. And so there was a good victory in the civil rights community while there was a real loss. I would say on that brief as well, so we filed a brief noting the Alan Katz from University of Michigan database and how little success had been had at the statewide level. At the local level, Section 2 does great things. And I was usually talk about it as, well, the people in the case were like, I'm not sure we really want to file, and be like, hey, John Roberts, leave us out scraps. It's only helping us a little bit. Just leave it for us. But we thought, this is going to give him a great way to uphold the act. But now the point that you make is yeah, dip for now. And then the next thing is, let's throw out the umbrella. Because, of course, we didn't say in our brief that everybody thinks they're bound by Section 2, and therefore it affects the way they operate. Yeah. Cool.
It is reminiscent of the court's parents-involved decision. So another race case at the elementary and high school level, where part of the argument that John Roberts made was, well, if you use race, so he had them coming and going. If you use race too much, that's a problem. If you use it too little, that's a problem, right? Because if you're using it too little, then it's using race for its own sake. And if you use race too much, then it's harmful. So that line did remind me of the parents-involved reasoning, which there's a lot of seeding in Roberts' opinions that come back later in subsequent decisions.
So if you're taking notes on this case, Allen v. Milligan, you'll note the Voting Rights Act explicitly says that no racial minority group has a right to proportional representation. And that's been interpreted by the Supreme Court to mean there's no right to proportional representation. And again, in Alabama, there's 28% of the population is African American, and 2 districts out of 14 would have been 28%. So that would have been very proportional. And the Supreme Court said, you're not guaranteed proportional representation, but if your lack of proportional representation is due to the history of discrimination in your jurisdiction, then there is some legal remedy there to get something that's roughly proportional at the end. And one of the concerns was because of the Shelby County case, the Supreme Court has said, we don't really care about a history of what's happened in your state. That's irrelevant. And so to say that some of these remedies are rooted in history, I think teed up some of this. And in the Supreme Court case last term, essentially they accepted all of the evidence that was presented in Alabama and said, we accept that there's been a long history of discrimination, and so we're going to require Alabama to draw a second district. With all of these underlying side notes about, I'm thinking the day after Shelby County was announced, we get Windsor, which is a case that goes in the opposite direction. And in one case, the dissent saying, how can a court overturn an act of Congress? And the next day they're saying, wait, how can you do this? And so there's been this attempt, I think, strategically. Ruth, you talked about State Voting Rights Act. So if Allen v. Milligan has said the Federal Voting Rights Act, so far, is still good, we still endorse the approach that we take in evidence, what is the purpose of having a state VRA besides a backstop? Is it giving us more? If Connecticut now relies on the state VRA, can they do more than they would with the federal VRA, or is it just a nice thing once the hammer finally drops?
No, that's a good question. I mean, Virginia passed a VRA that really just tried to act as a backstop. So, like, we'll just incorporate the current federal law into our law, so if it goes away, we might have something. But Connecticut is sort of the most expansive of the ones. So in California, they tried to take away some of, and it passed in 2001, the state VRA there tried to make it a little easier for litigants, right? At the moment, Federal Voting Rights Act cases are very complex. You have to get fancy experts like Doug Spencer, who's an expert in my federal VRA case. And, you know, it takes a lot of time and money. So in California, they developed a sort of cheaper, more straightforward system, essentially getting at the same thing. Then Washington and Oregon expanded by saying, hey, you don't only have to get districts as remedies, right? What about cumulative or ranked choice voting? Even Justice Thomas has not terrible things to say about those forms of race-neutral election systems. But then New York and now Connecticut were like, hey, well, let's not just fix, you know, Section 2 of the Voting Rights Act. Let's have an action for voter suppression. Let's establish pre-clearance, right? So have their own pre-clearance system, which was like what the federal government used to have that was struck down in Shelby County. And Connecticut now is the only state to have a required statewide database of data. So like in some of these places that I have gone to, I lived in Chicago for many years, and it was almost impossible to be able to even make out a case against some local communities because they didn't really have enough of their election results. They were like on PDFs that you could, or like typewritten photocopies that you could barely read. And I was like, this is, like, they don't have enough data, so I can't sue them to tell them they're doing something wrong. Like, this is crazy. And so even just that one act, you know, here in Connecticut of saying, no, we have to actually gather all of the information and make it publicly available, so then civil rights groups can go through and say, oh, hey, here are some places with some problems. And the other nice thing I think about the state voting rights acts is they do try to set up a system where you don't have to end up in litigation all of the time. I feel like the longer I litigate, the more my message to students is, you should do everything you can to never end up in court, right? You should be working with the community, you should be working with the, you know, what will end up being your opponents. There are all of these things you can get through organizing that you cannot get through litigation. Litigation will get rid of the bad thing, but if you want the good thing, you need more than just litigation. And so I feel like the state VRAs set it up, so you have to send a notice letter, and then you have to wait for a certain amount of time, and there have to be a certain amount of hearings, and the public have to be told. All of those things, I think, are really good for democracy and involvement of communities in their local democracies.
I love that. It's beautiful. Okay, I have a case that may come before the Supreme Court. I don't even know if an appeal's been made yet, but it comes out of the 8th Circuit. And this one, to me, is a little bit wild. There was a judge in a redistricting case out of Arkansas. In the case is Arkansas NAACP versus Board of Apportionment. And it was a Voting Rights Act case. And the judge says, wow, this looks really bad. The evidence against Arkansas looks really bad, just like it looks really bad in Alabama. But there's something that strikes me as a bit odd about this case. It was filed by a civil rights group. It wasn't filed by the United States government. Now, when I go back and look at the Voting Rights Act of 1965, it doesn't say that private citizens can file a lawsuit to enforce the Voting Rights Act. And the judge says in a footnote, I realize I'm the first person to ever think of this or strike down a case on this grounds. No other case has done this. And you look through the history of Section 2 of the Voting Rights Act cases, there's hundreds and hundreds and hundreds of cases. And I think my last count is 18 of them were filed by the Department of Justice. And so this case was dismissed because the plaintiffs had no standing. Okay, fine. Then the 8th Circuit took that case, and they affirmed the lower court's ruling. That was a total surprise to me. And then the 8th Circuit voted to hear and rehear that en banc, and they declined to do so. So this case is out there. When the judge issued this ruling originally, I just thought, well, that's wacky. They'll certainly be struck down and overturned, and they weren't, and now I think, well, that's wacky. The 8th Circuit's doing something totally bizarre. Clearly, the Supreme Court will overturn that, but I'm not so sure. I'm curious your take on this issue, because it would totally demolish the ability to enforce the VRA.
Yeah, so there's two things. One of them is that there may be a middle ground because there's another case in the Eighth Circuit that pled Section 2 of the Voting Rights Act and 1983, 42 U.S.C. 1983. And so there's the hope that even if the Eighth Circuit is crazy on Section 2, they will allow pleadings to go forward using 1983 to enforce Section 2. You should all take Fed courts, it's great. But so that would be a reason. So the difficult thing for the parties representing the plaintiffs, the ACLU Voting Rights Project is doing that case. And I don't know what their decision is. They're just stressing out about should they appeal it, right? Because there's a version of they appeal it and the court says no private right of action for anybody in any circuit, right? Really big downside. Versus can we live with this for just the Eighth Circuit? I will also say that it's not that he had the idea, right? Justice Gorsuch in Brnovich writes, query whether there's really a private right of action under Section 2. And so this judge, I feel like this is part of the way that, there's a book about the conservative legal movement and how, putting things in dissents and concurrences tees up the next case. And so I don't know what they're going to do. I don't know if they're going to appeal, but it's a really stressful decision to make. Actually, that was part of my class yesterday with my students. What would you do? Would you appeal? Would you not? Right? I don't know.
The Supreme Court, in my opinion, in other cases, has been very skeptical of private rights of action. And I'm curious, do you think there's any merit to this? It seems historically to be completely wrong. But as just a matter of getting the jurisprudence right, textual analysis of the VRA, is there a world in which that is a reasonable position?
Is there a world in which that is a reasonable position? It depends on what the Supreme Court you have, right? So this is the point that Ruth just made. Justice Gorsuch sent up the bat signal, and then now you have a number of people responding. And when you look at the VRA, what has made the VRA work is because Congress and the court have both worked together to make the VRA work. So just fairly quickly, for Section 2 of the Voting Rights Act, so much of the jurisprudence under Section 2, after Section 2 was amended in 1982, so much of the jurisprudence there is a function of the court filling in a lot of statutory gaps, right? So you've needed both the court and Congress to work together to have the jurisprudence as well as the statute that we have. When one of those parties stop cooperating, like the court, and when the court essentially reads the statute very narrowly, which it didn't in many, many cases, including Thornburg versus Jingles in the 1980s, but also cases in the 1970s, the court read the statute very, very broadly to allow private parties to enforce Section 5 as right. So the court really read the statute fairly broadly, but when the court stops cooperating, that's the problem that we have. It requires both parties to work, both institutions to work together, because there are gaps in the VRA. So if you're going to read it fairly narrowly, the whole Thornburg versus Jingles framework of how do you challenge a Section 2 for vote dilution, that is a function of the court supporting the statutory scheme of Congress. You won't find it in the statute, and I think that's part of the problem without a court that is willing to support the vision of Congress.
Yeah, thank you. I want to move away from minority voting rights, actually, and talk a little bit about some campaign finance cases, but I want to ask you one more question, Key. You're one of the few people I know who supports the Voting Rights Act, I would say, and thinks it was a good bill, but has written that we need something else. And I think that most of the people that I read that write about this say, hey, the Voting Rights Act is great. Let's not get rid of it. Let's not get something new. Let's just make it work. And you wrote, and I don't know what year it was in the Iowa Law Review, this piece, The Death of a Super Statute, where you basically said, hey, even in the best version of the world, look at the Voting Rights Act. Look at in 2012 before Shelby County. Had we achieved the things that we thought we would get in 50 years? No, it just wasn't working. And so I'm curious how you think about this going forward. You're a person that I read who says it's okay maybe to throw this in the trash as long as you have something better on the table. What does that better look like?
Just to give you a very quick example example of what the motivation is. Many of you might have remembered seeing the kerfuffle that came out of the LA City Council. So this is an attempt to redraw the local districts, and there was an intra-minority fight between the Latino community and the Black community. And some of the conversations that some of the Latino members of that council were having among themselves that were admittedly racist. But part of the problem was the way that when you're drawing single member districts and the government is having to decide which group is going to get political representation, and you have the Latino community saying, hey, look, we're the largest minority group and we are underrepresented, and the cost of that underrepresentation, we're bearing it, but it's benefiting the African American community, and we would like something better. So the VRA, in many respects, as it currently exists, creates a set of zero-sum results that will increasingly pit minority groups against one another. Right? So that framework, the framework of the VRA, where you have a dominant majority and a subdominant minority, work really well when you actually have two groups. You can make it work in some instances when you have three, but now when you have more than that and you have a requirement against proportionality, then you're having to make really difficult trade-offs. So the question is, can we do better? And one of the things that we can think about doing better without compromising representation for underrepresented groups, right? So that has to be up and front and center. But you could do better by exploring alternative voting systems, electoral structures, or to put the point differently, we can modernize our voting rights framework, right? The 1965 version, nobody today is driving their car from 1965. And if you are like the lawyers and aspiring lawyers that I know, you've already changed your car in the last 2 minutes. Right? So whatever you were doing in 1965, and I know most of you are going, but I wasn't alive in 1965. Exactly, that's part of the point. Whatever you were doing in 1965, you are not doing any longer. So the question is, can we modernize our voting rights framework for a multiracial, multicultural democracy of the 21st century? And I think that ought to be the civil rights project of the 21st century. The 1965 VRA was a civil rights project for the 20th century. And so the goal is to move forward to modernize her today.
Optimism, see? This is good. That's why I live with Guy. Sure. There is, but if you have something that's on point. I appreciate that perspective. And, you know, I would actually opine to think that part of the modernization of the Voting Rights Act is to minimize the centrality of the way that we've used race in the past, and so that we can think in new possible ways going forward. So that's really, really helpful. Sure. Absolutely. Sure. Perfect. Yeah. No, I appreciate that. That's a helpful commentary to think about how we're talking about these issues. In fact, I'm actually going to move away from talking about minority political rights, so maybe this will hit a little bit better. I want to think a little bit about corruption and campaign finance. I know it's kind of a hard pivot. And I'm looking at you because we just read this paper of yours about corruption. And there's a case from the Supreme Court last term, maybe 2 terms ago, where the FEC filed a lawsuit against Ted Cruz. They were concerned about his use of campaign funds to pay himself back for personal loans. And I think this is especially relevant because now we've seen both President Trump and President Biden using campaign funds to pay for their own legal fees, either that they've made themselves, and I'm curious if you can help us understand why the FEC thought that was problematic and what that portends for the use of kind of money in corrupting our politics going forward.
So the case in question, from 2 years ago, the question was, if you have a post-election contribution, can a candidate use that to pay off their loans, right? And there was a rule that said, no, you can't. You can't use post-election contributions in excess of $250,000 to pay off your personal loans. And what the Supreme Court said is they struck that down, and I'll say in a minute why, but they struck that down as being impermissible. And so the question is, why should we care, right? Why should we care about these post-election contributions? Why is this any different from an ordinary campaign contribution? Why is there a greater risk of corruption? Is there a greater risk of corruption? So I think there are 2 main differences between an ordinary campaign contribution and sort of this post-election contribution that you can use to pay off your personal loans. The first difference is that the contribution personally enriches the office holder, right? So that's one very important difference. The second difference is that the contribution comes after the election. So why should that matter? Because after the election, the donor knows who's won. They also know who's in office. They know what that person can do for them. They know that the donation is going to personally enrich that person, not just in their campaign, but straight to their wallet. And so that sets up the kind of situation for what we call quid pro quo corruption, right? A kind of exchange of money for some sort of favor. And the favor might be a government contract or a favorable policy outcome. It is just kind of ripe for that kind of corruption. And so to my mind, that is a problem. I mean, I don't agree with where the Supreme Court ended up on that decision for that reason. I also have to say, I found it a little bit worrying, the rationale for it. So the rationale that was given was, well, this is going to have, if we allow this limit to continue, it's going to have a dampening effect on speech. Why is that? It's because a candidate might not take out a personal loan because they're afraid that they can't, that they're going to lose out on, they're going to have to pay for it, they're going to be in debt. And so that's going to affect the total amount of speech that's made, right? Because they're not going to take out the personal loan. So the problem I have with that is that that's true of any kind of contribution limit, right? Any kind of contribution limit is going to have a downstream effect on the amount of speech that can happen. So to me, when I saw that was a complete red flag. Like, I don't know if the court is eventually heading in that direction. We've seen hints of that in various cases, that contribution limits are hanging by a thread. And this just seemed like another example of developing arguments as to why eventually it might be feasible, or it might come to pass that limits on contributions are also going to be struck down.
Do you see that as a bad thing? And the reason I'm asking is, I think the Supreme Court has been blamed for creating a campaign finance system where more money is flowing to non-party groups and non-candidate groups, third parties, independent groups, super PACs. And that's led to a coarsening of politics, more negative campaigning, less control of the message. If you got rid of contribution limits, presumably more money would go to candidates themselves? Or is that thinking about it the wrong way? Do you think the court is to blame for some of the coarsening of American politics?
So I think that there is a real risk of corruption when you have those contributions made directly to candidates. But I think the problem with, let's say, super PACs is actually the decision in Citizens United that held that independent expenditures do not amount to quid pro quo corruption, right? So that actually was, I think, that brought about this big change. Because of that decision, that independent expenditures which don't have a coordinating role with the candidate, because those aren't seen as being corruption, what ended up happening eventually is that you had the emergence of super PACs. Super PACs have completely changed the way politics is conducted now, right? It's basically bypassed political parties, supplanted political parties in all kinds of ways. Political parties are no longer playing that intermediary role between candidates and the people, and they're no longer playing that regulatory function. So I think that the story is a little more complicated than just the contribution side. I think the fact that independent spending and the fact that in Citizens United, corporations and unions can now spend unlimited amounts from their general treasury funds, that's, I think, one of the sources of the things that we're seeing today. And I think that's truly problematic.
Can I ask a question? I really know very little about campaign finance. The coordination thing that you talked about, my understanding was that even though formally there's supposed to be no coordination, in actual fact, it's like the same lawyers in the same office managing two campaigns. Do you think it would help at all if there was a little more policing of the coordination so they were genuinely separate, or is that just not even worth it?
I don't know how you could police it, I guess. I think that's, it's a really good question. I think that the theory that there's no coordination is just, it just beggars belief, frankly. Every candidate knows who the super PAC is. It's impossible to monitor what kinds of conversations are happening. You're going to know who has donated. And the fact that they're unlimited donations, the other problem too is the lack of transparency. As compared to, say, political parties where there's more accountability and transparency, when it comes to super PACs, there's very little. So there's no way for the voter to really know what's going on. And the influx of money into the system, the influx of wealthy groups, of wealthy individuals, has, I think, completely changed the tenor of politics, especially with the collapse, not complete collapse, but the lack of power that political parties now have. I think they play a very important regulatory and moderating function, right? You're going to have far fewer extremist kind of candidates if you've got strong parties that can decide who's going to be our representative. But I think all of that has now shifted with the rise of super PACs.
One more campaign finance question that I even hesitate to bring up, but there's one trial that's going to happen in the United States before November election that involves a former President, Trump. Started yesterday or Monday. At the core of this case is a campaign finance violation, right? He's paid Michael Cohen $130,000 to pay Stormy Daniels $130,000, and either it's a private expense, he's trying to prevent Melania from finding out, but then you can't use campaign dollars to do that, or was a campaign expense, he doesn't want the American public to find out, in which case you have to disclose it. He did neither. And then it appears kind of lied about it on the way that he reimbursed Michael Cohen. Can you talk a little bit maybe about how campaign finance, is kind of working through that case? You don't have to take the heat for this, but people may be interested, since it's on their TVs all day, how election law fits into that case.
Right. So, I think part of the problem I have in untangling that whole case is that the crime apparently, or the misdemeanor, is altering the business record. So the fact that this expense was listed as legal expenses when in fact they weren't really legal expenses, right? But that's only a misdemeanor. So to make that a felony, the prosecutor has to show that this misdemeanor was done with the intent of yet another crime. And the other crime in this case happens to be the campaign finance violation. So it's a bit of a convoluted route, I think, to get there. On top of it all, the president says that, it's a little confusing because he says there was no encounter between himself and Ms. Daniels, in which case it's not really clear why the money had to be paid. But that's a whole separate conundrum. But I think that it's not clear to me that this is an easy case to win, actually, just because it is not that straightforward. It's not obvious to me that it's going to be easy to show.
Why don't you think a case was filed challenging the payment originally as a campaign finance violation? I think that was part of the Mueller report. What do you think prevented that initial lawsuit?
So, I mean, I think that Michael Cohen was, in fact, prosecuted, and he was charged with a campaign finance violation. So I'm not sure.
President Trump.
Oh, President Trump. Why didn't they go for that directly? That's a good question. I'm not sure why it wasn't just a direct thing. And I think, maybe it was a lack of evidence. I'm not really sure. It could be that this was just seen as an easier way to get to the problem. I don't really know.
That's fair. All right, I'm looking at the clock and realizing I would love to hear more questions or comments about what's driving you anxious about this election that you think you'd like to hear more from our panelists. And I have more too if there's not questions, but I'd love to open up from the audience. In the back, Yuri Min.
Hi, we know from Buckley v. Vallejo, 424 U.S. 1, 1976, that campaign finance regulations are only justified if their primary purpose is to prevent corruption or what we call the appearance of corruption. How close are we getting to finding out what the court thinks is the appearance of corruption?
Guess is that the appearance of corruption is corruption itself. So I think that, because as you see, and I'm curious to hear what Yasmin has to say about this, it seems to me that they are closing down what they see as every loophole. So the anti-circumvention rationale is gone, and the openness that's left is appearance of corruption. And they seem to have defined corruption as quid pro quo corruption. So to the extent that the court believes that Congress will use appearance as a way of re-energizing campaign finance regulations the court has struck down, then I think it will further shut down or redefine what appearance is to be essentially actual corruption. But Yasmin, you might have a different view.
I completely agree with you, Guy. I don't think appearance of corruption is going to save the day, if that's the question. I think you're right. I think they always throw it in there. They say actuality and appearance of corruption, but it doesn't, from what I can tell, do any independent work.
Fair enough. Thank you. Any other questions?
I was wondering if any of you were surprised about the outcome of Trump v. Anderson, and specifically there was sort of a hidden 5-4 split in that too. So,
I guess I'm on the panel as the person who is not surprised. No, wait, was I? Yes, no, I wasn't surprised in this case. I'm going to take the Guy role. No, I mean, I just think they were going to find some way to not do that. It seems like it was going to break down the whole system. I mean, there were some interesting textual arguments here and there. This is the case about, whether Colorado could independently kind of kick Trump off the ballot. I think that there were good enough ways to do it. I wasn't that surprised with how it came down. Is that where you were? Yeah.
I think it was pretty clear where the court was going. The question was whether it was going to be 8-1 or 9-0. And of course, the concurrence by Justice Sotomayor agreed with the general outcome, but obviously disagreed with the way that the court decided that how Congress could enforce Section 3 and the enabling legislation that it would take. That Justice Sotomayor wanted to leave more options open to Congress, but I think the oral argument, to the extent that there were questions, I think the oral argument answered which direction the court was going to go.
I'll just add, I'm not necessarily surprised for the same reasons because of who sits on the court and what they had said about it. But I think that there's still some real tricky issues to flesh out in future cases. We don't have an election for President of the United States. We have 50 different elections. Every state runs an electoral college. And so if you want Colorado's electoral college votes, you've got to follow the rules in Colorado. And if you want Ohio's electoral college votes, you've got to follow the rules in Ohio. And the Supreme Court's been very clear about that in the past, that states have the authority to run their own election to decide who's going to be the elector. And so in this process, Colorado said, as part of our decision of whether you can be on the ballot, you're going to have to gather signatures, pay a filing fee, not do an insurrection, all these things. And so for them, it was just, this is what it takes to win our electoral college votes. And there was a case directly from Colorado many years ago when an elector from Colorado who went to the electoral college voted for somebody else. I think voted for Kasich instead of for Clinton. And the court said, of course the state can decide who's going to be elector. So there's very strong language even from the conservative justices who kind of led this charge to say no way because it would create a patchwork. But for me, watching that, I think there's already a patchwork. So what makes this patchwork different? And some of it was technical about enforcement of the Section 3. But in that way, I'm not surprised at the outcome, but I thought that they didn't describe what they were doing in enough detail to give me satisfaction that there's now a clear path forward for how a state should run its electoral college.
Can I ask you a quick question?
Yeah.
If you put Chiafalo together with Trump versus Anderson, Anderson versus Celebrezzi, Moore versus Harper, it seems that the court seems to be sending a message about national, like elections, presidential elections, but even congressional elections are national. And so we seem to have sort of like this tension, right, between the practice that you're describing and then the expectation that people have, especially at the presidential level, that they are voting, and that they're voting for president, that it counts, and that it's a national thing. How do you think through that question?
I think of that in terms of a political question doctrine, right? Do I think that do I think Chris Murphy represents Connecticut as the senator, or do I think he represents the interests of the United States because he sits in the United States Senate? To me, that's a theory of representation that it's odd for a court to say, we expect Chris Murphy to care about the United States and not about Connecticut. And so why am I going to tell Connecticut they have to do a certain approach to this? So for me, this was the kind of case that if the federal court said, this implicates too much about the foundations of what it means to have representative government to stay out, that is how I probably would have approached the case because of exactly this point. And Anderson versus Celebrezzi that they cite in Trump v. Anderson, it says, what we do in Colorado affects what happens in Florida. And again, I guess, but you get our 5 electoral college votes, that's it. And then Florida, you do something different in practice. They seem to kind of gloss over that. There was a hand in the very far back.
Hi there. Thank you again for coming and speaking to us. I had a question related to the gerrymandering issue. What are your thoughts on ranked choice voting, and is it the answer that the lobbyists are saying it will be?
I think we have at least one yes on the stage.
Well, so I will say not all ranked choice voting is the same, but to the extent you are talking about using ranked choice voting for multiple winners, that's great for enfranchising historically disenfranchised communities, right? You can be in fact, in Virginia Beach, this was where Doug was my expert, one of the issues at the remedy stage was what remedy the city of Virginia Beach should have, and it was very weird alliance between a couple of council members that represented, they were the candidates of choice of the black community, and one person who was a member of the Tea Party and had been mostly elected by the Tea Party, and all of them, because they would never get over 50% of a citywide vote, were on board with ranked choice voting, and the rest of them were not, right? So it's not only about racial and ethnic minorities, ideological minorities will be represented as well. So I do think if you teach ranked choice voting in class and you're like, oh, so there's this system and it does these things and it has, and you don't have to draw districts and do gerrymander, et cetera, then when you teach the rest of the course, people are like, why don't we just do that other thing? So I don't know that it's always a panacea, but it's pretty good.
Yeah, I have an anxiety.
Okay.
I have a bunch, but having to
Safe
do with
space.
election law, which has to do with election administration, what's going to happen in the fall, and the role of the courts in overseeing it. I mean, claims about fraud and also the way in which some of the positions, state positions might have been sort of, targeted. And anyway, so I'm just curious about, I don't know if this is to you, Doug, or to who this is. Yeah.
So last summer, I got a phone call. I don't even know how. Oh, he got my desk number from the Secretary of State of Nevada, Cisco Aguilar, and he's like, hey, I have a problem. We have 17 county clerks that run elections, and 11 of them are new. What do I do? And I was like, thank you for your intake call. That seems like a difficult problem. So it turns out there are groups that are working on this, right? So one of them is new people. And so what can you do? So there's all of this literature in, actually a lot of it comes out of the, basically public service, right? So what can you do to recruit, retain, and support people who work in government? And so in terms of recruitment, right, how do we get people to be poll workers? How do we get people to be county clerks when they're getting doxxed and all of these other things are happening? So some states have passed laws to sort of heighten the protections on election workers. And we're going to do some interesting studies as to what effect that actually has this year. But it at least maybe has a sort of comforting effect that there's a law there. In terms of retaining people, it turns out there are all of these things you can do to sort of develop networks, right, between people who are dealing with the same problems. So it turns out Cisco Aguilar, Democrat in Nevada, is actually kind of good buddies with Stephen Richer, Republican in Maricopa County, because both of them are dealing with a lot of sort of election deniers and trying to work out what to do. And by being able to say, my program is exactly the same as the Democrat's doing next door, or for the Democrat, my program's the same as what the Republican is doing next door, has actually been helpful. And then the last thing I'll say is that, again, it has to be bipartisan, right? So Ben Ginsberg has set up the Election Official Legal Defense Network, EOLDN. Could probably use a better acronym. But he's setting up lawyers around the country. And I said to him, like, oh, can I get, some of these law firms are alums. And he's like, we don't really want, the Harvard lawyers to turn up and help, in the middle of, Kansas that has a problem, right? Our thing is to get lawyers who are respected amongst Republicans to represent election officials when they are targeted sort of for personal attack or, once sort of counting happens. So there are mechanisms in place that, or I guess they're all being tested out, right? There's a lot of things being tested out to try to make things better. And so hopefully one of them will work.
I'll just add also to this point that Guy was making about our elections being very national, at least the presidential election, the way the court talks about it. One of the big challenges and blessings of the United States elections is it's super decentralized, right? It is operating at the county level. And it would take a lot of corruption. If you put every ballot on the internet, you could have corruption instantly. But if you have 3,000 different ballots in 3,000 different counties, it would take an enormous amount of corruption, and I would also say an enormous amount of incompetence for that to really have a sway. So yes, I think there will be more problems this election kind of in the mechanics, because there's a lot of rookies running these offices than there may have been in the past. I don't know that that's going to lead to more corruption, but even if it leads to more incompetence, the fact that we are operating thousands of independent elections is some level of backstop. And usually that would give me a heart attack. 3,000 things have to go right in one day, but in this case I would say 3,000 things would have to go wrong, and so maybe there's less space for that kind of anxiety, because I think the likelihood is that everything's going to run smoothly.
If I may just say very quickly, we went through a pandemic and also a very high-profile election. There were two institutions that actually stood out well. Election administrators did an unbelievable job throughout that process, and the court system actually worked really well as well. That doesn't necessarily mean that in the future, but under stress tests, both performed extremely well, and I think that's something that we should be comforted by.
Yeah. All right, one final question.
Thanks so much, for all of your insights. Just returning back to campaign finance for a second. In Citizens United, the government advanced three state interests, the anti-distortion, anti-corruption, and shareholder protection. And Yasmin, I got the sense from your comments that you found the anti-corruption argument persuasive, but I was wondering if you could comment on the other two rationales and how persuasive you found them, mindful of the fact that the court dismissed all of them.
I think that what I found quite sad about Citizens United was that the court tossed out the anti-distortion rationale, right? So for many years before Citizens United, there was this broader, more capacious understanding of what corruption entailed. So corruption wasn't just quid pro quo, wasn't just an exchange of money for a favor. It was also this idea that people who had undue influence on the system, that was a kind of corruption, right? So if you know, at one point, maybe they still do, politicians would have these menus of access where you could, if you donated a certain amount of money, you got lunch. If you donated a little more, you got dinner. If you donated a bit more, you got a whole weekend with that person. And so there was the thought in an earlier case, in the McConnell case, that actually amounted to a kind of corruption. That was wrong. That in a country you shouldn't have people being able to buy time with a politician. You shouldn't be able to buy access and buy influence in that way. And I think that more capacious understanding of corruption, I think, accords with how most of us think of it, right? That you shouldn't be able to buy your way into getting a favorable outcome or getting more time with a politician. And unfortunately, in the Citizens United case, the Supreme Court threw out this anti-distortion rationale, saying that, you know, it's too close to a kind of egalitarian or equality rationale, where you're trying to level the playing field or level the voices that are speaking, and that's, you know, contrary to the First Amendment. So I think that's actually had a very damaging impact on politics. The fact that that the anti-distortion rationale has been tossed in that way, and even more worryingly, the what's left on the table, which is the quid pro quo corruption, has become, I think it's shrinking. Every time I read a decision, it seems that quid pro quo means something even less, right? And so with the decision that we were talking about earlier, with the loan repayment, the Cruz decision, it doesn't even seem to mean quid pro quo anymore, right? Where when you've got kind of an obvious sort of exchange, or the obvious risk of an exchange, or certainly the appearance of some sort of favor being done to line someone's pocket directly, that doesn't count as quid pro quo. In fact, the court said there was scant risk. I'm thinking, scant? We have very different ideas of what amounts to scant. I mean, this just seems like classic, you know, kind of quid pro quo in action. So I don't even know what it means anymore, actually.
All right, we are actually 5 minutes over. I appreciate you sticking around later than we had advertised time. Please join me in thanking our discussants for coming today.